and start looking at whether or not they fit well into this model of a permanent disqualification and a 5-year disqualification. And obviously that's something that was proposed by Mr. Page and others. And we had some great comments last time, but just want to kind of take it for a little bit of a ride and see how those things fit in. Any questions from anybody on the subcommittee before we move forward? And the other thing Mr. Vogel, I think knows, or I know he knows about it. I have to bring my daughter to her drum lesson at some point, so I'm going to bow out. Lucas, do you think I could hand this off to you with about 10 to 15 minutes just to kind of keep us going?
Sure.
Okay, nothing like springing that on you, Lucas, but
I'll roll with it.
One of the curses of being fantastically competent in this world is people give you more and more and more and more. So I hope you take it as a
percussion. That's cool.
Mr. Vogel, please update us on that most recent data set. And I know I put you on the
no worries. Thank you, Mr. Chair.
Appreciate it.
Yep. So this is the most recent DHS data set, which I sent out a copy of, and you should also have gotten a spreadsheet version, which I made. So any errors on my own, please let me know if you catch any in there. But this is essentially responding to some of the work the data analysis subcommittee has been doing. And they sought not quite so much clarification as data that was presented differently than previous data, which they find easier to work with. So I feel like that's kind of opaque. But basically, they've been working with the disqualifying crimes and conduct and statistics on what they're calling eligibility to work versus ineligibility to work, essentially a outcome like getting a set aside or a variance, here's the list, versus outcomes like correctness affirmed or not set aside. So just to quickly walk you through this data set, table 1 is showing us these categories by look back period for 2018 and 2019. So, for example, and I'd note these are among people who requested reconsideration. So this isn't the entire statistical universe of disqualified individuals. But as we can see, among people who received a 7-year disqualification and then applied for a set aside or some other sort of remedy, the majority of them received a favorable outcome in 2018, for example. Moving on to table 2, we have reconsideration requests requested in the first place by the look back period and the disqualifying crime or conduct that initially led to the disqualification. That's redundant.
Hey, Will.
Yeah, definitely.
Can I ask you one question just on that first screen?
Mm-hmm.
If you go back up to it.
Oh yeah, absolutely.
So this data goes to 2018 and 2019.
Yeah.
Why would anything still be in process?
That's a fantastic question, Mr. Chair. I can follow up with DHS actually and ask them that.
I think I'd like to know just why data sets 4 years old still have cases that aren't resolved.
That makes a lot of sense. I guess I'm too close to this. I didn't even notice that.
Sorry for interrupting.
Oh, no worries. And as we know there, well, I don't want to speak for the department, so I'll definitely pass that along. So table 2 essentially breaks down by look back period and crime the entire group of people who request reconsideration. Table 3 then does the same thing for those who received the favorable outcome that we're calling eligible to work. Table 4 does the same for applicants who received the unfavorable outcome. And then finally, table 5 essentially recapitulates table 6 of data set 3 in a form that the data analysis subcommittee will hopefully find more helpful. Essentially collapsing the crimes or conduct to give us total numbers of, for example, convictions for first-degree controlled substance crime, whereas table 6 of data set 3 gave us that data by look back period, which led to some imprecision if you tried to add up all those numbers. I can explain if anyone's interested, but I don't want to take up too much of anyone's time. And I would imagine that Chair Kammerer will definitely be wanting to delve into this data set in the meeting on Thursday.
And I would further state that if there is anything,
Mr. Chair, I'm not seeing you as muted, but I can't hear you.
Can you hear me now?
I can, yes.
Okay. I was just going to say that if anybody wants this data analyzed in a certain way for Professor Kammerer, they should reach out to Will or directly to Professor Kammerer prior to next Thursday or anytime. I know that subcommittee is looking for other ways to kind of crunch numbers. I did have another question, Mr. Vogel. On a couple occasions, we had questions about specifically the 152.18 cases that are routed through sort of that first-time drug offender case and whether those are disqualifying. I know that you had sent in a couple of requests to the department. Had you received a response yet?
I haven't yet, Mr. Chair.
Okay. Can you, when was the last communicate? Did you receive a response at all to that request?
I did, Mr. Chair, acknowledging that the request had been received. Just a moment, let me check when that correspondence was. There we go. That was last Wednesday, Mr. Chair.
Okay, and that was the second request?
Yeah, that was the request for a clarification on cases that involve a pardon or that are discharged through 152.18.
Okay, all right.
I'd also note, without wishing to put her on the spot, Mr. Chair, that we do have Emily Cassane from the department here. So if you wanted to amplify that request through her.
I'm glad you're putting her on the spot. I was going to be very polite and not do it, Emily. Hi, Emily. How are you? Yeah.
Thank you.
Do you have any information on either of those requests?
I will. I've been out for a little bit, so I'm sort of getting caught up on emails, but I will definitely track those and get back in touch with you as soon as possible.
I appreciate it. Thank you so much.
Yep. Never mind being put on the spot.
Well, everyone's pretty good sport about it in this group.
They're
so
very good. Yes.
Does anybody else have any questions for Ms. Cassane or for Will or anybody else before we move forward and start looking at the permanent disqualification list? Okay, thank you, everyone. So what we're going to do today, and just so people maybe who are streaming it or maybe going to watch this later, the idea now is, one of the ideas is to replace the existing structure of a 7-year disqualification, 10-year disqualification, 15-year disqualification, and permanent disqualification is moved towards a 2-tiered approach with a 5-year disqualification and a permanent disqualification, which, as I understand it, is more in line with the Adam Walsh Act and some other states. And one of the things we wanted to do as we start moving towards looking at that model was just start looking at some of the permanent disqualifications, some of the 15-year disqualifications and so on, and have a discussion about where they might fit. We certainly don't need complete agreement today, but opening up a discussion on some of them. So we're just going to go through some of them. Mr. Vogel's going to pull up the disqualification list, and we're going to go through it and just sort of see where we think they would be as a recommendation. Let's just start at the top. And Mr. Vogel, so the 3 options, I think, for anything technically, and this will be for everything that we go from permanent disqualification to 7-year disqualification, would be, should it be a permanent disqualification? Should it be a 5-year disqualification? Or should it not be a disqualification? I'm anticipating a lot of the permanent disqualifications won't get many of the no disqualification votes, but we might have some. And we want to include those 3. Would it be possible, Mr. Vogel, just to kind of track how we're going here, and again, if there's consensus, if there's not? So
Certainly, Mr. Chair.
Okay, so the first one we have is, I think, an interesting one, which is violation of the predatory offender registration. Judge Kulik has had some discussions about this where I think even with younger people, this could be not really what it seems to be. It could be an effect of homelessness. It could be effective, really a lot of things. So what do people think about where the violation of a predatory offender registration should go? Should it be permanent, 5-year, or not a disqualification?
And one thing I think that we should keep in mind as we talk about this is there is an underlying serious conviction that created somebody's status. And that in and of itself, we don't need to worry about necessarily failing to register, especially if it's tied to homelessness. I think there's going to be a bigger disqualification for the underlying matter. But that really sad anecdote that I shared was about a kid who's was a registered sex offender, and his offense was when he was 11 years old and in foster care. And in the 20 years since then, and when he was coming into court, he had never had another sexual reoffense. He finally got out of the system, but was pretty broken and was addicted and homeless. So there were trespasses and little thefts and C-5, possession of small amounts of drugs. And he fell out of contact. But that's all he had done. I did give him a departure because I didn't think it warranted sending him to prison over that. He hadn't hurt anybody again, so he wasn't a danger to society. But that's where anybody who has to register as a predatory offender has a pretty serious conviction that's going to pretty much take care of it. So I'm not sure. Are there cases where that's not the case? Because I can't think of any. And then it just seems like we're adding a permanent disqualification on top of a permanent disqualification. And why put it on the list, or why not? That's my 2 cents.
Thank you, Judge. Ms. Dawson.
Thank you. And I just wanted to highlight back the remedies subcommittee had looked at the permanent list, I think back in April and May. And I believe one of our consensus was the violation of the predatory offender registration is not actually required by the Adam Walsh Act. And so I think at least in the remedies subcommittee, there was some consensus that it should be removed as a permanent registration, partially along the lines of what Judge Kulik mentioned, where the majority, the reason somebody's already on the list is it's a buildup from a different crime that would already be on the list. So it's essentially a double dipping. The safety is already considered. And I guess I would also comment, I think what is also highlighted by that report that had been sent out a while back is some of the issues with the predatory offender registration. For example, the fact that Minnesota does not even track and cannot even tell us how many people have to register based on a juvenile offense. And so I think that starts to encompass and brings in individuals and other concerns that I don't know that were actually ever contemplated.
Let me ask you this question though, Lucas. Are we repeating work that's been done in remedies by going through this list?
Potentially.
Okay. And my thought was that remedies was more looking at the the permanent DQ under something kind of broad and looking at the set aside provisions within, not looking at whether or not they would be disqualifiers.
So
Okay.
we did look at the permanent DQ list, and I apologize. As people were talking, if I had a funny face on my, as I was showing it, I was trying to find the notes that we had kept that I sent to Will. I don't know, maybe Will can find those. I know I had done a PowerPoint.
Mr. Chair, Ms.
I-
Dawson, I actually just sent out a copy of the May 16th version of those notes, which I believe is the most recent.
Okay, perfect. Well, I think I had done, yeah, I think there's a PowerPoint somewhere too, but remedy is now moving on to the set aside. So part of that part of it, but we had looked at the actual permanent DQ list itself.
And when you were looking at the permanent DQ list, were you determining whether it should be, what were you looking at? Like whether it should still be on the permanent list?
Yeah, we did do some of that. I think the consensus we came to was that most of the crimes listed on the permanent list are required by Adam Walsh. We're not going to get around them no matter what. There were a small handful that I think we determined maybe would not have been required. And I'm happy to just quickly let you know which ones those were from the notes.
Maybe that makes the most sense, because if we're gonna have to stay consistent with Adam Walsh, maybe focusing on those that are not included in Adam Walsh makes the most sense. What do others think about that approach today? Okay, so Lucas, could you guide us through the list a bit? And
So, and oops, sorry, I minimized the wrong document. There we go. So based on what we had done, looking at this handy little Excel spreadsheet, I think we determined that, so the felony domestic assault, if the victim is not a spouse or child, that would not require a permanent disqualification. So domestic assault can include more than a spouse or child would be covered under Adam Walsh, but not, let's say, a roommate or a parent or some other household member.
do you, so can we, and I apologize, I think for the ease of Mr. Vogel too, do you think that's under line 10 and it would be qualified by who was involved?
Yes.
Okay, could we highlight 10,
Yeah.
Mr. Vogel, and then add maybe just that note, because it's a little complicated, I guess.
Yeah.
A couple things to know is domestic assault is an enhanceable offense. So the first one is going to be a misdemeanor, but they get more and more serious. So when you get to a felony domestic assault, that is going to be because it's repeated. Also, it includes siblings, spouses, ex-boyfriend and girlfriend. One of the things that we look at, though, is if the victim is especially vulnerable, that would be a child, or if it's an intimate partner relationship where there's it's clear that there are power and control issues.
Yeah. And I think for the purposes of our discussion, it was really more, it's what's not required by Adam Walsh. And then obviously that's open for all of us to discuss whether it's still on the list.
Yeah.
So then the other one, a felony first degree assault would be a 5-year under Adam Walsh. Same with second degree. The drug offenses are a 5-year. So the chapter 152.
Are there permanent?
Those should be under the 15 years, I'm correct. Just a moment.
Yeah, and those may be on the 15 on my notes. They're just because they're part of Adam Walsh.
Okay.
Yeah, 152 is under the 15-year disqualification.
Yeah.
Okay.
And then
Was the reporting, I mean, so the top one we were looking at, that Judge Kulik was weighing in on the violation of predatory offender, that's not on Adam Walsh, right?
that's correct. Yes.
Okay.
So I think we separated it out by what would be a 5-year under Adam Walsh and then what's just not even listed on Adam Walsh. And the
Okay.
violation of the predatory offender is not listed. There's a criminal sexual predatory conduct. Line 25. So that's not technically on Adam Walsh, and that's similar to like the violation of the predatory offender, where it's linked to a different offense that would already be a permanent disqualifier. Incest is not listed, is not an Adam Walsh requirement. Great bodily harm by the distribution of drugs. That is number 12.
Mm.
And then I think we had at least some question, I think I think depending on the factual basis, solicitation, the 609 .322.
Number 18.
Yeah, so like if it's a child, obviously that would qualify, but certain other ones may not. And then the felony level harassment or stalking. I think again, those depending on the underlying facts.
How would they, so you're saying under Adam Walsh, it would depend on the facts? Can you give me a little insight into what
Well,
is
because
that?
Adam Walsh covers if there's a use of force, essentially, if there's a use of force element, which would be like the physical assaults and the batteries. So even like a felony harassment stalking, I think we determined would likely not include a permanent bar, but more of a 5-year bar. That was essentially how we had separated some of those out. And
Okay.
then Adam Walsh did not require judicial determinations other than convictions or a preponderance of the evidence or even juvenile delinquency adjudications.
Okay.
And I think. And then I did highlight, I mean, our statute is missing what I think would be required by Adam Walsh would be in 2019, we enacted the child torture statute. And I don't think our statute's been updated to reflect that one.
So we have to give back all the federal money that the states received since 2012 because we're not in compliance?
No, just since 2019.
Oh,
when it-
2019, my apologies.
Yes.
I think that's really helpful. Thank you so much, Ms. Dawson.
Yes, and I think from our perspective, I mean, a lot of those, at least from our perspective, are crimes. I don't know that we would say, well, remove them altogether, but they're not technically required for a permanent bar.
Okay. Focusing then maybe just on the ones outside Adam Walsh, because I think that's a bright line to me to look at the difference between the two. And we've had some discussion of violation of predatory offender registration. I have significant issues with the predatory offender registration. And I think you can see a lot of times where it's failing. It seems to me that the fallback and what's so helpful is what Judge Kulik said, is that it's always tethered to some other issue, and maybe you focus on the real issue and not what could be, somewhat innocuous or, unintentional registration violation. So just to open up the discussion on this real quick, do people think it should be, a permanent, a 5-year, or altogether just removed? My vote's on remove, but I'd love to hear from others.
Just so you're asking only about the violation of the predatory offender.
Yeah, under the first one, line number 2. If is there a reason to have it under the disqualification statute? And if so, should it be a permanent or should it be a 5?
So if we have Mr. Chair, if we have someone who is has to register, that I'm just trying to think of which crimes they would have to register for that this would be worth restarting the clock for. And maybe there aren't any as your suggestion, and that's why it doesn't need to be on there.
I mean, there are registration cases where somebody is charged with, kidnapping and, I don't know, car theft. And then the kidnapping is dropped and they get convicted of the car theft. But since the two are connected and kidnapping is one of the offenses where registration could be required, you have people who are never convicted of that, kind of predatory offense, but still registering. And I think it can kind of cut both ways. Not everyone that's registering is kind of who we think they are.
Would you like a rundown of which, when registration is required under Minnesota law? Because I've got my statute book open.
Love it, Judge.
Okay, so, murder, kidnapping, criminal sexual conduct, indecent exposure under 61723. That might be one of those that's, it's creepy, but, surreptitious intrusion under the circumstances described in 609746. Yeah, I'm not sure about that. False imprisonment, solicitation, inducement or promotion of prostitution of a minor, engaging in sex trafficking, a prostitution offense in violation of section 609324. I hope there are no old throwbacks when we were just prosecuting victims there, but that would be interesting. Soliciting a minor for sexual performances, possessing pornographic work involving a minor. That's about it. Or if you've been convicted of something similar from another state. So there's a lot, and there's some variety there.
Well, and I think to John's point too, along those lines, you could have somebody, and that's something where, I could have a client who's charged with a crim sex, and let's say they're ultimately offered some sort of a assault of some sort or something kind of lower than that. But if they take it, they're still required to register as the predatory offender because it arose out of that same conduct.
My suggestion would be that just because they did not plead to that doesn't mean they were not engaged in that conduct, and that might be part of the calculation that the prosecution is making, is that they will, agree to plead the case down to get a certain conviction and have that period of monitoring.
Mhm.
So I don't think I just don't think whether they were convicted or not necessarily is an indicator of whether the underlying conduct was especially predatory or not. And so for that reason, I feel I would have to think about this more to see if all of those underlying crimes would fall under in terms of Adam Walsh, or if everything is covered by at least a 5-year disqualification period, then this one may not be as big a deal. I don't know how technical the violation of the predatory offender registration terms are when we decide to prosecute those cases. I have not prosecuted those cases, but I'm hesitant to say to just remove that one without doing a little more looking.
And I apologize, but do you think your question is whether it should go away or it should be a 5-year, or is the issue more of whether it should remain permanent or be a 5?
I'm open to just about anything. But I just want it to be my decision to be an informed one, which will require a little more homework on my part, which I can do.
And maybe we can figure out some that are difficult to kind of revisit after maybe even a little more research and discussion. Yeah, Ms. Dawson, please.
And I was just gonna add, to me, I think the compromise would almost be a 5-year of some sort versus, I guess, getting rid of it altogether. Although I am looking, I think the remedies subcommittee was recommending that our statutes be it's essentially more in line with the federal requirements. I don't know that we specifically said remove these ones that are not, but just that our statutes come more in line with what's required federally than adding these additional requirements. And I always found it rather odd. I feel like the violation one was added at a later date, if I remember correctly. And so I don't even believe it. If I remember history wise, I don't even think it was always there. So that's just another point. But to me, the compromise would be some sort of a 5-year.
And, it might make sense, although my position is it should go away. It might be more palatable to people for it to be a 5-year. I mean, it certainly does involve language such as predatory offender, and it just might be more intelligent to have it as a 5. And there's a significant change from permanent disqualification to 5-year. Anybody else have thoughts on violation of predatory offender registration? So I guess that one gets a question mark. And maybe Mr. Vogel, we can kind of, and maybe, working with others to try to figure out what the next step is with that. I want us to be intelligent about it, but also be mindful that, we want to be able to get something done. And I think Mr. Page is right. We need to be more informed on it. So let's move to the felony assault in first and second degree, and then domestic assault. We'll just take them one by one. I have to admit, I was pretty surprised that felony assault in the first degree is a 5-year under Adam Walsh. Does somebody want to talk about or have the ability to talk about what assault in the first degree is? And certainly anybody who wants to weigh in on an opinion on what it should be.
First degree assault involves great bodily harm, which I believe is the highest degree of harm someone can experience under the way we've defined harm, which I think means permanent dismemberment or, losing a limb or something like that, or there's a whole definition. It also includes, though, use of deadly force against a peace officer, prosecuting attorney, judge, or correctional employee, use of dangerous weapon against any of those individuals, causing great bodily harm to any of those individuals, and then the sentences vary depending on what you engaged in that conduct. So,
Judge, have you seen many felony assault ones come across your bench, and have any thoughts on what that looks like?
Have never had an assault 1. Lots of 2s and 3s, lots of 4s, lots of 5s. But yeah, nothing higher than 2.
and it looks like with 0 criminal history points, assault in the first degree has a presumptive prison commit of 86 months.
That is correct.
Thank you, Mr. Page. Thank you, Judge. Well, what are people's thoughts? Is this something that needs to stay consistent with Adam Walsh, or is it something that is more severe that the state wants to, or we should recommend more protection than it? Yes, Ms. Dawson.
Well, I think I would say, speaking on behalf of the remedies subcommittee, I think remedies felt that it should be more in line with Adam Walsh. And I think also just sort of keeping in mind, even if it's a 5-year, that doesn't mean that that person is automatically going to have access. And I think that goes to, for example, that email that Mr. Page had sent about employers still maybe receiving access to this information. Employers can still request that criminal history background. So I think that essentially leaves it in the hands of the employer. If, for example, there's a reason that maybe somebody is not, after 5 years, maybe they've done the rehabilitation or whatever else may be necessary, that they are safe to employ, then that's in the hands of the employer to actually make that decision based on their needs and the actual individual versus simply a statute and what's there. And it's consistent with Adam Walsh.
You know, it seems to me that there are kind of two other pieces that are out here that aren't really in our assessment at this point. One would be, you know, if you have a presumptive commit, and it's 86 months, or even if the person were put on probation for 5 years, it could be we're adding 5 years to the 5 years to make it 10 years, depending on when we're having our start date for the clock ticking for the 5 years. And I know that one of the suggestions that came from Mr. Page, I think, was once somebody leaves the Department of Corrections and that sentence is complete, if they had the 86 months, I can't do my 2/3 math, but it sounds, it's adding a lot to 5 years. The other question to me is, if we're saying permanent, are we saying permanent with no possibility of a set aside, or are we saying possibility of a set aside? Because obviously under the current law there is no wiggle room. If you're on the permanent list, it's over. Your circumstances, the situation is irrelevant. You may not get a set aside. So that strikes me as two things that kind of muddy the water a bit. Ms. Kaser, please.
Thank you, Mr. Chair. I'm actually looking at a chart that DHS puts out about disqualifications, and that particular one does look like it is a permanent disqualification, not a 5-year for the first degree. Second degree is a 5-year. And it does say permanent bar applies, but if subject is under 18 at the time of the background study request, they can submit a variance. But that's just assault in the first degree felony.
Is that chart specific to the foster care rules, or is that
It is child foster care, but this would apply to family child care as well. So, and this is not the new laws in effect. This is an old chart that still
Okay.
applies with the old.
I guess
So.
we should make sure we should be all looking at 245C
Right.
to make sure. I always thought 2 for some reason was a permanent disqualification.
I believe it is, Mr. Chair. So you should be able to see my my copy of 245C right now. And subdivision 1 lists a felony offense under 609.221 or 609.222, which is first and second degree assault. So I'm a little confused about that chart, honestly.
Well, and actually, I think I can clarify some on that a little bit. The Adam Walsh does not require assaults. The Child Care Development Block Grant does. I think if you go back, Will, there was a handout you had sent a while back that really kind of breaks down both of those. And I think right now our disqualification statutes are simply a blanket, sort of the most restrictive of all of the federal requirements, which was why the remedies subcommittee was recommending that the background study is essentially differ depending on the population that there would be access to. And so, for example, we were recommending that statutes or essentially background studies that require the Adam Walsh or the Child Care Development Block Grant be limited to the disqualifications necessary to comply with those statutes. But that individuals who work with substance use disorder positions and facilities or any disqualification based on juvenile contact or conduct be treated differently. So I think that might be where some of the confusion is coming in, but the Adam Walsh, based on even what DHS had sent out, did not include those assaults. And I know that was and I relied very heavily on that when I did a presentation for the large group, I think back in May.
Ms. Kaser, when you were talking about the handout or whatever it was, were you saying that it was a DHS document that identified what the disqualification statute is, or what the federal rules were?
It's what the Minnesota statutes apply for disqualifications. So it's
Okay.
not necessarily applying what Adam Walsh is, but I'm sure it's in compliance with whatever Adam Walsh is. And this is what the background studies unit uses supposedly when they're doing their initial background studies and looking at disqualifications.
Further emphasizes how complicated some of this stuff is and how it is hard to dismantle or untangle. Mr.
Mhm.
Page.
Thank you, Mr. Chair. I think if we send out of this working group or task force, whatever we're called, something that says first degree assault should be a 5-year, I think we run the risk of not being taken seriously. And so although I believe that people have the capacity to change, I've seen people have committed much worse crimes change. Out of practicality's sake, I think it should be a permanent disqualifier. I'm intrigued by the idea of the ability to set aside or get variances, however, for a permanent disqualification because of my belief in capacity to change. But in terms of, it strikes me as the kind of crime that if we said that should be a 5-year disqualification and the prison term is actually longer than that, even with the good time served is longer than that, I just think the rest of the work which has been really good, won't be taken seriously.
Okay, I appreciate that.
Mr. Page, it's kind of the politics of it too. And yeah, well said, Mr. Page.
I mean, one of the things, and maybe this is for Mr. Vogel poor Mr. Vogel, get to us is what are the numbers? Like, is there a significant amount of disqualifications based on first degree assault?
I could have an answer for you in a minute or two, Mr. Chair.
I think I'd like to know, because I think knowing the numbers changes a little bit of what we do. You know, if the number is 2, is different than 500, and I can't believe there are that many, but I think at some point it would be interesting to know. Ms. Austin, do you know if the Adam Walsh Act or the Child Care Development Block Grant prohibits, as part of the permanency, setting it aside?
Was that a question for me? Sorry.
It was.
I'm sorry. I guess at least the remedies subcommittee had interpreted the Adam Walsh. I mean, Adam Walsh says permanent is permanent. I don't think, at least as we were looking at it, the Adam Walsh didn't have room for essentially a set aside or anything like that. That seems to really be a creature of Minnesota statute versus a federal requirement. But I do think our permanent bar list, which is under, if it's the 245C.24 or whatever it is, I believe that covers most of what would be permanent DQs from Adam Walsh or the Child Care Block Grant. But yeah, I think it does cover the assault in first degree and second degree as well.
Okay. Ms. Dawson, I'm going to turn over this meeting to you. Everybody who was here before, I have to bring my daughter to an appointment. I wish I could stay longer. I wish we were here for like 2 more hours, because this is fascinating, but difficult. I will be in touch. Thank you all so much. Thank you, Ms. Dawson.
Thank you. And I guess Mr. Page, maybe it makes sense to go back to the remedies subcommittee. Will be moving on as our next topic to that set aside portion of the statute. So to me, I think, Will, if you could make a note for my memory that does not seem to go as far out in the future as I would like it to bring definitely your concerns to the remedies subcommittee as far as, at a minimum, let's say first degree assault. Maybe pulling that out of the permanent, for example, set aside list. The permanent is permanent, but perhaps looking at a different structure for those set asides to potentially do it that way.
Certainly, Madam Chair. And I actually do have an answer for Chair Gavin's question. In 2018, there were 20 disqualifications for first degree assault, disqualifications and therefore permanent bars, and 103 for second degree assault. In 2019, it was about the same proportions, just a little larger, 35 and 238.
So I guess my interpretation would be, it definitely seems like the first degree assault is just a smaller portion of the population. It seems to me the second degree assault would just affects a larger group of people. Hearing what Mr. Page said about first degree assault, I guess, what are people's thoughts then on second degree assault? And I guess I can even throw out an example. I mean, I had the client who, I've seen it a number of times, the domestic where somebody drives off in the car and a car is a deadly weapon, and whether they hit the person or the other person says they tried to hit them or whatever it might be. But that's where, at least those are the ones I seem to see where it arises out of the domestic, that essentially the car got involved. And at least in the few that I've seen, seems to be somebody's trying to actually leave the scene, and it just essentially continues. Now, obviously there are multiple other examples and multiple other instances, and I've definitely seen others, but that seems to be at least a reoccurring one. So with that,
Assault in the second degree, Madam Chair, is also what's used to typically charge a lot of these assaults where someone uses a firearm. I mean, that's the other most common type of dangerous weapon, I think, that is used to prosecute these, which, we see a number of them in Hennepin County, maybe less elsewhere.
Yeah, no, I've definitely that one. The other one, a knife. I've seen the knife. But yeah, so understanding that, what are people's thoughts on a permanent? Is it a permanent? Is it a 5-year? Is it something else?
Unfortunately, there is such a difference between the domestic with the car and the gun. And there are two subsections to the statute. One is just the assault with a dangerous weapon. There doesn't have to be any harm. There can be just fear, but it's still an assault with a deadly weapon. It could be the car. And how different subdivision 2 is, because it's dangerous weapon and inflicting substantial bodily harm. And I wish we could differentiate those. You can't set up a system where people have to make judgment calls all the time on, let's see, was this a domestic with a car? But it's just unfortunate. Certainly, if you assault another with a dangerous weapon and inflict substantial bodily harm, that's pretty serious. And I would think I'd be comfortable with at least a 7.
Okay. What about anybody else?
I think it could certainly stay. I mean, I think if we're keeping to that schema of either permanent or 5-year or nothing, I would certainly at a minimum say 5 years.
Oh, yeah. And I think, I think the remedies subcommittee had definitely looked at it as, I mean, this is definitely not, well, it's required by Adam Walsh in the child care block grant. So it's for sure on there. And I think at least the remedies subcommittee had at least seen some reason to move it to the 5-year, but obviously there are, what Judge Kulik pointed out are very good points to make.
Madam Chair, the new foster care licensing statute lists a felony level violation for assault in the second degree as a 5-year disqualification period, to the extent that we're trying to remain somewhat consistent with that. Unless the assault is committed against a child, then it becomes a permanent disqualification. I don't know if that distinction is necessary for purposes of our work. But that is, we could certainly differentiate and say permanently if one uses a gun or a car or something. And
no, but I think that's helpful, and I definitely can see. I mean, I guess to me, if you are looking at fostering somebody, I guess to me, that's the type of circumstance where we'd want to be protective. And so I guess to me, it makes, my point would be, it seems to make sense to be consistent with that statute and not have differing timelines for different circumstances. I like consistency. So, well, I don't know if maybe you could put a note on that, just to maybe revisit. And I see it is 4:57. I know it's end of the day, we're all kind of tired. Does it make sense? Would people be all right if, rather than trying to start the conversation on felony domestic assault, which I know Judge Kulik made a number of very good points on earlier in the meeting, if it makes sense to maybe adjourn here and we can pick up there next time?
Well, I know I have to leave in 2 minutes, so don't let that stop you if other people.
I think it makes sense then just to stop rather than try to start a conversation and then stop and all of us try to remember exactly where we were.
And Madam Chair, I can send out a copy of this document to the members.
That would be great. Thank you. And maybe, Will, would it help everybody? I had done a PowerPoint back in May to the large group. Would it help everybody if Will just resent that out? It was a recap of what the remedies subcommittee had looked at.
Madam Chair, I think I actually did earlier this hour. Perfect.
All right. I didn't know if you'd sent it to everybody, but yeah, just so people can kind of see, because obviously that was May and we're obviously much farther past that. And yeah, so that was a while ago. Perfect. All right. Well, I will adjourn the meeting and see everyone. I'm not sure when our next meeting is. Will, when is it?
2 weeks from now, Madam Chair, so that'll be the 23rd of August.
All right. Perfect. We'll be